Okay, our next speaker will be Travis Leathman with Disability Rights Oregon. Travis joined Disability Rights Oregon as a staff attorney in 2022. He earned his bachelor's degree from the University of Utah and his law degree from Temple University in Philadelphia. Before joining Disability Rights Oregon, Travis was the judicial clerk for Judge Nan Waller in Multnomah County Circuit Court, primarily covering mental health court and aid and assist docket. Please welcome Travis.
Howdy. All right, so glad I can be here this morning. Big caveat, just since I'm an attorney, I'm going to give some general advice today. Please don't take any of it as legal advice. If you do, have things that come to mind that you could use help with, feel free to reach out to our organization. I put my email up on the board. I hope you can see that. I promised I'd bring my business cards, but as a person with a disability, I'm going to ask you to accommodate me for forgetting to do so. So really today, I wanted to give you a brief introduction of our organization, kind of our mission, what we do, very briefly, and then jump into talking about employment. Essentially, as people with disabilities, there are legal protections in place in the workplace in terms of getting accommodations. I'm also going to talk a little bit about vocational rehabilitation. So first, Disability Rights Oregon is the protection and advocacy system for Oregon. Protection and advocacy, or P&A, the thing we throw around a lot in my sphere, kind of like the watered down version. Back in the 19th and 20th centuries, if someone was disabled, they could be involuntarily hospitalized, institutionalized indefinitely without any legal protections. And in the beginning in the 1960s, there were a number of legal interventions that were put in place. The last legislation that JFK ever signed into law was to begin expanding the rights of disabled people with disabilities. In the late 1960s, early 1970s, the federal government created what's now called the Protection and Advocacy System. Essentially, every state and territory in the United States has one P&A authority. It's a non-governmental structure that has broad authority to advocate for and defend the rights of people who are disabled. And Disability Rights Oregon is our state's P&A authority. Essentially, if you have a question about whether or not you or a loved one is the type of person that could get services from DRO, if the question is, do you or your loved one have a disability? And if the answer is yes, you can always come to us for legal services related to disabilities. We have a wide purview in different things that we cover, guardianship issues, Social Security. I could go on and on. Today, I'm really going to be focusing on what I cover, which is accommodations work. We have a few different contracts. One is our PABS contract, which is for beneficiaries of Social Security. If you are a beneficiary of Social Security and you're facing barriers to employment or need to resolve a dispute with your employer over reasonable accommodations, that's something you could reach out to us for to discuss. the thing that I really is my bread and butter that I really work on every day is under our PAIR grant, which is for protection and advocacy of individual rights, which is assisting individuals with disabilities to get reasonable accommodations in housing, employment, education, transportation, public accommodations. If essentially our goal is to help any person with a disability engage in a society that is not always built to accommodate. Finally, we also have our client assistance program, which serves folks that are receiving vocational rehabilitation services. These people receiving vocational rehabilitation are adults with disabilities looking to obtain, maintain, or advance in employment. Also could be youth with disabilities transitioning into the workforce. Sometimes disputes come up when people are receiving vocational rehabilitation services. That's something that we can intervene and help people resolve. And if you're glazing over because I'm talking about reasonable accommodations and vocational rehabilitation, you're like, what the heck is that? We're going to talk about it a little bit more. So really focusing on the employment issue, the Americans with Disabilities Act, specifically Title I of that law, covers employers with 15 or more employees and requires equal opportunity for qualified individuals with disabilities to benefit from employment opportunities. And really the primary way that we can go about ensuring that that qualified individuals' rights are being respected is by the reasonable accommodation process. For just for those who are curious, the ADA recently celebrated I think it's 25th anniversary. So if you were like listening to Pearl Jam in the 90s, then you lived before a time where the federal government codified the right not to be discriminated against as a person with a disability. So I find that a little surreal, but I'm really grateful for the ADA. So reasonable accommodations require employers to make reasonable accommodations or modifications for known physical or mental limitations, or a modification or adjustment to a job, a work environment, employer policy or practice, or the way that things are usually done. Can kind of explain what a accommodation isn't. Essentially, a person should be using the language of going back, really. They're talking about equal opportunity for qualified individuals. Means that an accommodation is not to restructure a job that the person wouldn't otherwise be qualified for. So for example, I have ADHD. I can request reasonable accommodations so that I can do my job more effectively, but I still need to be able to maintain my bar license. I still need to be able to go in front of a judge and make arguments and give presentations on Saturday when needed. So while a reasonable accommodation is not something that can make an employer carve out and create a new job for you, it does require that they make sometimes significant modifications or adjustments so that you can do a job that you are otherwise qualified to do, and that the only barrier to that is a disability. I often have people come and ask me, what exactly is an accommodation? Like, what can I request? What can't I request? Is there a list that I can look at? And the short answer is there's not. And that's because it really is the sky's the limit. Every person is different. Every person's disability is different. Everyone's needs are different. Every job is different. And so really the accommodations process is supposed to be a flexible way of working with your employer to find a solution to support your disability so that you can do your job. That being said, some common accommodations are physical changes to your work environment. I think if you've ever been in a building with a wheelchair ramp, that is a physical change. Accessible communications, maybe you need something in writing. Maybe you need someone that is proficient in sign language to communicate with you. Adjustments or modifications to training materials, including accessible formats, part-time or modified work schedules, unpaid leave for medical treatment for a disability, accessible and assistive technologies, policy enhancements, job restructuring, or assignment to vacant positions that are a better fit for your disability needs. My colleague and I were brainstorming about some accommodations that could be beneficial for individuals with epilepsy in particular. This could be a request to have a flexible work schedule. And again, depending on your disability, maybe there's certain times of the day or certain things that are more likely to trigger an episode. So building a work schedule that works around that. Requesting breaks to take medication. And there's a specific time that you need to take your medication that doesn't normally go with the normal break schedule with your employer. That's a very reasonable accommodation. Having a private place to rest after having a seizure. Requesting that your employer purchase a rubber mat or carpet or cushioning in your work area in case you have a seizure. Having a checklist to assist in remembering different tasks. Other options is permission to bring a service animal to work or permission to work from home. And for a lot of folks that I work with that have have accommodations to work from home, can be a hybrid policy, or some folks work from home 100%. So I kind of so just because you have a request that to you feels reasonable doesn't mean that it necessarily will be deemed reasonable under the law. Essentially, an employer can argue that an accommodation should be denied if they can argue effectively that it's an undue hardship. An undue hardship can be an undue financial or administrative burden, can result in a fundamental alteration to the business, or pose a direct threat to the health or safety of the employer or to other people. Just kind of as some examples, and again, every accommodation is different, every employer is different, and so it's really impossible to say what is an undue financial burden, what isn't, unless you actually know who the employer is. If your employer is St. Vincent's Hospital versus a clinic with 20 employees, their financial resources are going to be different, and the amount of funding that they'd have available for an accommodation is going to will be different as well. Results in a fundamental alteration to the business. For example, if you are you're a school teacher and your request is to work from home remotely 24/7. Well, if you have kids in the classroom, your employer, the school district, will be able to say that allowing you to work remotely would be a fundamental alteration to the business, and therefore they're going to deny the accommodation. Something that poses a direct threat to the health or safety of the employer or others. I always use the example of like a service animal. I work in an office. we have people that bring service animals into our office all the time. If I worked on the floor of a sheet metal factory, it might be different. It might not be wise for me to be bringing a service animal. And so kind of case by case on the work that you're doing would depend on whether something would be a direct threat to health or safety. That being said, I want to make a big caveat. Sometimes I meet with people and they say, I wanted to request that my employer let me have this accommodation, but I was thinking about it and I really don't think it's reasonable. Like, I don't think, I think they could argue that it's an undue hardship. Don't do that. If you request something and your employer thinks that it's a reasonable accommodation, great. They're the ones that decide that it's unreasonable. If it's something that you feel like is going to be a good accommodation for you, ask for it. That being said, just because your employer deems that an accommodation is unreasonable because it's an undue hardship, that doesn't mean they're off the hook. There is something under the ADA called the interactive process, which means that if you request an accommodation and your employer deems that it's unreasonable, they are legally obligated to have a meeting with you and talk through different options to find something that will be an accommodation. I sometimes call it the Rolling Stones rule. You don't always get what you want, but you get what you need. So for example, your employer might be concerned about having a service animal in your office because of someone with allergies. But as an alternative, they allow you to work remotely when that person's in the office. That could be a reasonable accommodation. The interactive process really can be informal. Often offices, different employers will try to make it very formal and put in guidelines with HR because that's what HR does. Really, it can be as casual as going out to get coffee with your supervisor and talking through the issues and finding something that works for you. A reasonable accommodation request can be made orally or it can be made in writing. An example for an oral accommodation that I did recently. Again, I have ADHD. I cannot sit through a meeting that lasts more than 15 minutes without getting fidgety and distracted. And so I usually knit or doodle while I'm in meetings. And so I told my supervisor, hey, I can't focus in these hour and a half long meetings that we do at DRO sometimes. So I need to be knitting. Is that okay? It's for my ADHD. And my supervisor said, cool, no problem. That was a reasonable accommodation request. I let them know that I have a disability. I let them know that I need an intervention to help with my disability. And my supervisor approved it. So that's really all you need. That being said, I'm an attorney. I recommend getting things in writing whenever you can. If things ever go sideways, the more that you have documented, the better. So I generally recommend making accommodation requests in writing. Doesn't have to be a super fancy formal letter. It can just be an email to your employer saying, hey, I have a disability. Because of my disability, I need to bring my service animal to work. Or I need I need to install padding around my desk. I need whatever it is. Will you grant this accommodation? And if they say yes, perfect. Often employers will request that you fill out forms on the back end. Just in terms of HR, they might have a special form that they want you to fill out. As long as they're not requesting information that they're not legally pertinent to, I recommend going along with it. But I just want to be clear, you don't have to do that in order to officially make an accommodations request. You might need to provide some information to your employer in order to get a reasonable accommodation. Essentially, that includes verification of a disability-related need as needed. When you're requesting accommodation, you do not need to tell your employer what your disability is. Kind of depends on what your relationship with your employer is. As I've told you 5 times today already, I have ADHD. My employer knows that at this point. So if you feel comfortable with that, go for it. But that being said, you don't need to. You can say, I'm a person with a disability, and because of the disability, I might need to take more frequent medical leaves of absence, or I might be more prone to falling and injuring myself. So you do need to be able to explain what the accommodation is and why you need it, but you do not need to tell them what the disability itself is. If you ever need help workshopping that language, most doctors are comfortable with kind of putting this language together. You can always reach out to our office as well, and we can help walk through that. You do not need to verify your disability if the need is apparent. If you have had a seizure in your office and your supervisor knows that you've had a seizure in the office, they've been put on notice of the disability. And so there's a strong argument that you're not going to need to provide a note from your doctor confirming that you have a disability. I have a colleague that's quadriplegic. She comes to work in a wheelchair every day. She doesn't need to provide notification from her doctor saying that she has a disability. And sorry, I should clarify with that. The verification of a disability-related need usually is just a note from your doctor confirming that you have a disability and why you need it, why you need the accommodation. Again, they don't need to provide detailed information, don't need to give your diagnosis, absolutely do not need to share your medical records. It honestly is pretty straightforward. Medical privacy. So under the ADA, employers are required to keep all of your medical information private, even if it's not related to a disability. Any disability-related inquiry or medical examination of an employee must be job-related and consistent with business necessity. Worked with a gentleman recently who has injured his knee on the work site and needed to have a medical examination to determine if he could continue doing his job. That kind of inquiry was appropriate. If you tell your employer that you have epilepsy and need accommodations, they cannot ask for you to have tests. They cannot ask you to get a second examination. They cannot inquire about the extent of your epilepsy and the symptoms, and any of that is inappropriate under the ADA. In terms of keeping your medical information private, that extends to your accommodations. So if I'm sitting in a meeting and I'm knitting, and my coworker says, "Well, why is Travis allowed to knit in the meeting?" My supervisor is not allowed to tell them that I'm doing it because of my disability. In terms of if you face discrimination in the workplace, whether or not it's something explicit in the way that a coworker or your supervisor is treating you, or if a reasonable accommodation's been denied, there are different enforcement agencies that can investigate and take action on your behalf. There's no cost to filing charges for discrimination in these organizations, and you do not need a lawyer in order to file a complaint. Those include the Equal Enforcement Opportunity Commission, which enforce federal anti-discrimination laws. Also includes the Oregon Bureau of Labor and Industries, or BOLI. The thing that I recommend doing is if you feel like you are being discriminated in the workplace and you'd like to file a complaint, I would start with BOLI, because BOLI and the EEOC have an information sharing agreement. So if you file with BOLI and they determine that there's a violation of federal law, they're going to share that information with the EEOC. So it's kind of two birds with one stone. File with BOLI, don't have to file with the EEOC. If you feel like if you don't really know if that's something that you want to do, happy to talk through that with you. Finally, vocational rehabilitation. We always say voc rehab or VR because saying vocational rehabilitation is really hard. There's essentially, if that's something that you feel like you could benefit from, if you are a person with a physical or mental disability and you are either trying to get into the workforce or you are trying to advance in the workforce and you need vocational assistance, possibly, maybe that's education, maybe that's technical support, maybe it's counseling, then you could be a candidate for VR counseling. It really is like a county by county process on how that works. So I would just look up for the VR counseling in your area to complete that service questionnaire. Again, if you don't know how to start that process, reach out. I'm not going to get super into the weeds about this. Essentially, there's like a formal process that you need to go through when receiving vocational rehabilitation. And as I mentioned, if you have problems with your VR counseling, whether that's getting through the door or whether that's having an issue with the services that you are receiving, that's always something that we can help with.